It's a great pleasure to talk to you here today about the impact of Brexit on the legal status of union officials and other servants of British nationality. The reason why I'm talking about this today with you is because not only was I invited by ERA to do so, but the European Parliament Jury Committee, the Legal Affairs Committee, had asked me to produce a study which you can download from the European Parliament, which is very much the basis of my findings. Because they asked me to look into what does it actually mean for civil servants and officials and other servants of British nationality to be faced with this Brexit situation. Now, as we all know, Brexit has a lot of negative consequences for citizens and for companies around Europe, not only in the UK, but also in the rest of the European Union. But especially hard hit will be the officials and other servants of British nationality. And when you think why, it is actually interesting to look at the background legal situation. Looking to the treaties, it is not that the treaties themselves had required that people working for the European Union should be union citizens. Neither Article 336 of the TFEU, as the legal basis for staff regulations, provides for nationality, nor does Article 298 of the Treaty on the Functioning of the European Union, which is the legal basis for an open, efficient, and independent European administration. Neither of these two provide for nationality, and actually Article 11 of Protocol number 7 to the TEU and the TFEU, there's a specific protocol which deals with a lot of matters of servants of the Union, explicitly grants rights and privileges to EU officials and other servants, whatever their nationality, leaving it entirely open. The only little link to the idea of public service and nationality we have in the treaty is actually with regard to fundamental freedoms. Article 51 of the TFEU famously, explicitly allows for a link to be made between nationality and the exercise of official authority, but that within member states, where member states can reserve certain types of jobs for their nationals. So the idea of linking citizenship with the role as an EU servant is entirely a legislative choice. It's an old one, admittedly. No one had ever, when making such choice, considered that a member state would leave the European Union, yet the rules are unfortunately very clearly written. Because, for example, if you find under Article 49 of the Staff Regulations, the English language is slightly more polite than the French or the German. The English language says, an official who ceases to fulfill the conditions laid down for employment, which include, under Article 28 of the Staff Regulations, the requirement of citizenship of a member state of the European Union. Such official, as the wording says, may be required to resign. Now, that sounds very polite and very friendly, but peut-être demi, kann entlassen werden, is much more clear in the sense of the word, which is, it's not the servant which may be required to resign and has a choice then to resign or not, but it is actually the employer who can terminate. Article 47 of the rules which we have for other servants, the CEOSU, establishes that the employment shall cease simply with a loss of citizenship, even more drastic. So when we look at the results of Brexit for citizens of UK nationality who happen to be servants and other officials of the Union, what we do have to acknowledge, first of all, is a very clear legislative choice, which sounds rather disheartening at first sight for those affected. But we can see one little beam of light, which is, as usual, there's no rule without exception. And the staff regulations and CEOSU provide for the right to request a decision for an exception to the requirement of holding EU citizenship, both for officials and for agents. Now, we have certain precedents. There had been certain Norwegians who were hired in the services of the European Union when it looked like Norway would join the European Union, and these people who had joined the public services of the European Union had later on gotten exceptions to continue on in the services. Now, Article 90 of the Staff Regulations allows officials and agents to submit a request to the appointing or their appointing authority to take a decision relating to him or her, and therefore, if you make such a request as an agent or an official, you have the right to a reasoned answer. And since the possibility of exception exists, a decision by the hiring authority to grant an exception, the linking of those two provisions, one the right to make a request and the other the possibility of an exception, giving individuals the right to a reasoned decision about whether such exception can be granted. Now, the problem obviously is there is broad discretion on the side of the hiring authority whether or not to grant such an exception. So we have to, when we want to understand what are the conditions of this granting of exceptions, understand, of course, the conditions of the exercise of discretion. Now, obviously, there are certain framing general principles of EU law. That was the context why the European Parliament asked me to conduct the study, to see whether we could bring to bear some of these general principles in order to narrow down the discretion and make the decisions to a certain degree more predictable and therefore to a certain degree fairer because of a little bit more objectivity brought in. Now, when looking at these principles which could be brought to the exercise, one of them is the right to good administration. Since entry into force of the Charter, also formulated in Article 41 of the Charter of Fundamental Rights. And this Article 41 is not very well formulated because what the Court of Justice does, and has done long before Article 41 was formulated, it has been developing case law which is now formulated as, in Article 41, paragraph 1, as fair and impartial decision-making. The Court of Justice had developed a principle of care for a long time beforehand, which lots of scholars say has been included into this right to fair and impartial decision-making, and especially with regard to staff matters. The former Civil Service Tribunal and the General Court have been very active in developing the devoir de sollicitude, which is probably the better word than the obligation, the duty to solicitude. The devoir de sollicitude is what this caring relationship is supposed to be expressing a little bit better. Now, what does that mean in practice? The Court of Justice, in its various formations, as you know, the Civil Service Tribunal, of course, no longer exists, has developed this quite a bit and has found that with regard to discretionary decision-making by a hiring authority, that hiring authority should take into account, and here I cite, not only the interests of the service, but also those of the official concerned. And, importantly, it requires the administration to look after the well-being of its officials. How far this now reaches, this duty of solicitude, this devoir de sollicitude, in the face of fairly clearly worded Article 49 of the Staff Regulations and Article 47 of CEOS, is of course something which is difficult to discern, because the clearer the legislative choice as to what is the principle, the more difficult it becomes to say looking after the well-being of the officials is necessary. And in that context, it is important to see that, of course, the principle of proportionality reigns supreme over any decision-making. Any decision-making will be reviewed as to its compliance with proportionality. However, in the face of the explicit legislative choice of saying, in principle, it is union citizens who are officials or servants of the union, the devoir de sollicitude in the context of proportionality will probably soften the edges more than take the blunt of the actual decision. Soften the edges in the question of timing, soften the edges in the context of conditions under which, for example, certain rights such as social security, health insurance and others will be granted. Now, the problem also is that another general principle of EU law, which is often used for these matters, which is the right to legitimate expectations and the protection of legitimate expectations, which you could say, if, as an official, I have entered the services, Article 44 of the Staff Regulations lines out my future career. As long as I'm a loyal servant, I will be able to move along within the prescribed framework. That these legitimate expectations are no longer complied with. Well, the case laws of the Court of Justice, unfortunately, is quite clear. Even if there were explicit assurances by the authorities, even if the commissioner in charge would have come out and said, we will ensure your future employment. That, which did not happen, of course, as we know, in explicitness. There were certain, terms which were employed which mitigated that. The Court of Justice says that no assurance of an authority of the union can violate the law. Legitimate expectations do not exist where there would be violation of the law. Given the explicit terms of the staff regulation with regard to nationality, the legitimate expectations possibility, therefore, even with assurances of words of institutions, is difficult. So the angle one could find most likely would be assurances plus exceptions. So the assurance with regard to the granting of the exception could, under certain circumstances, lead to a powerful weapon for the individual official and servant affected, but not just per se, with general declarations. Now, obviously, if you read Article 41 of the Charter, the idea of timing is important. And I think everyone will accept that legal certainty for the individuals affected by Brexit as servants of the union and officials of the union is important. And of course, one might say it might be the interest of individuals to wait for the decision to take as long as possible, because that would increase their time in the service of the union. But I would assume, and that's of course a guess of mine, that most would like clarity in order to get on with their lives and change whatever career track they need to change, if that is what they have to do. So the idea of timeliness can be used as an argument for requiring a certain decision making, but is of course potentially a double-edged sword. When we look through the situation of individual officials and other servants of the union, we of course not only have the core, which is the employment situation, but other aspects like pensions and sickness insurance. With regard to pensions, obviously, staff members of the EU acquire pension rights against the European Union as a legal person. Brexit does not change this. There was a lot of talk about whether the pensions would be rolled over onto the United Kingdom. That is not possible, in my view, legally. The right is against the EU as a legal person. So, in that context, whichever agreement the European Union will find with the United Kingdom, and there are certain political pre-agreements which have been discussed as to the payment of the UK into the pension schemes, or a lump sum payment when the UK leaves, that does not as such affect the legal situation of the individual servant. With regard to sickness insurance, after leaving the service of the EU, an official, as you know from looking at the staff regulations, may apply for a prolonged coverage in sickness, that any servant leaving also for Brexit reasons can do. And there is the possibility, especially in justified cases for individuals who suffer for certain chronic conditions, who would have difficulties finding coverage otherwise, to receive unlimited coverage. And that is, I think, one of the areas where especially the duty of care, the devoir de sollicitude, will come in, and proportionality aspects will play a large role in those individual cases where that is the case. So far to the rights. The remedies, of course, we know, judicial review against the decision, especially a decision under Article 9 of the Staff Regulations, requesting an exception. However, the problem with the Court of Justice's review of discretion is we have on one side the general principles, but on the other side the famously lax review with regard to the way things were done. The Court of Justice states that it must limit its review in regard to staff cases as to, I cite, whether there was a violation of essential procedural requirements, whether the decision was founded on factually wrong or incomplete findings, or whether there was a misuse of powers, an infringement of union law, or an insufficient motivation. So, given the prominence of the devoir de sollicitude and the developing case law of the Court of Justice in the context of duty of care, there's one area where a lot of possibilities of review exist and are expanding even under this problematic formula, which is the question of whether the hiring authority has taken into account all relevant facts and has done full and impartial assessment of all relevant facts. And this is an area where the Court of Justice has been opening the door and allowing for much more judicial review in the past, I'd say, decade than it had previously. So therefore, the question of review of discretion in this area, whereas there is, albeit broad discretion, as we see, is to really ensure that all elements have been taken into account. That will also be very relevant with regard to the softer, not the core employment matters, but especially things like sickness insurance and other aspects. But we'll have to see what the outcome in these cases will be, and I actually would be astonished if there wouldn't be one or the other case going up to the Court of Justice. The problem is for individuals affected by Brexit, there won't be time to wait and watch and see what other cases result in and then move. Everyone will have the same kind of deadlines in an action for annulment, 2 months, to bring their cases if they so see necessary. So I hope the trade unions of the civil servants and agents of the union will support with legal advice. Because the only alternative, the only real alternative is, of course, a complaint to the Ombudsman. And as we know, the Ombudsman is a very powerful institution in finding friendly solutions and negotiated solutions. The problem is there is no binding and enforceable decision coming out of the Ombudsman's procedure. So, what happens when all of this is done? Let's come back to the primary law, draw the big circle, Protocol number 7. Protocol number 7 on the privileges and immunities of the European Union includes, as you know, the rules on individual rights of residence and taxation of servants and officials of the Union. And that protocol obviously will also cease to be applicable within the United Kingdom after Brexit. Therefore, there is, of course, a little bit of attention to be paid to that. For example, only within the territory of the European Union and of its member states will individuals be exempt from national taxes on, I cite, salaries, wages, and emoluments paid by the Union. So tax residence will be relevant. And of course, especially for pensioners, such residence will not always be entirely straightforward, having the right to reside. And another problem when we look at the primary law of the European Union is, of course, also logic as a consequence coming from Brexit, which is the principle of non-discrimination on the basis of nationality, which equally is no longer applicable towards third country nationals, which then will be UK nationals. So even the Court of Human Rights in Strasbourg has accepted that the European Union and its member states, on the basis of union law, can distinguish between nationals of the European Union and non-nationals of the European Union. So there isn't really even much hope in Strasbourg from non-discrimination, and therefore the third country national status of UK citizens outside of the Union hits officials and agents particularly hard in this respect. Thank you very much for your attention, and looking forward to your questions.